Assalamu alaikum wa rahmatullahi wa barakatuh. This is our video assignment for the subject Administration of Islamic Law in Malaysia, whereby we were given the task to review 2 cases. Hence, we will take a look at the facts of each case, its issues, and the ground of judgment. For the first case is Hajah Halimatussaadiah binti Haji Kamaruddin versus Public Services Commission, Malaysia, and another.
Firstly, we'll be discussing on the facts of this case, Hajah Halimatussaadiah binti Haji Kamaruddin versus Public Services Commission, Malaysia and others. So the appellant, a clerk in the Perak State Legal Advisor's Office, had been wearing the purdah during office hours in contravention of Service Circular No. 2 of 1985 pertaining to dress code of civil servants, in which this circular prohibited lady civil servants from wearing attire covering the face during office hours. Both the State Legal Advisor in Perak and the senior officers from Pusat Islam Jabatan Perdana Menteri had met her to explain regarding the state circular and dissuaded her from wearing the purdah. Unfortunately, she took no notice of the advice and persisted in wearing the same attire during work on the grounds that as a Muslim, she was required by the Quran and Hadith of the Prophet to cover her face and not to expose it in public.
The disciplinary board for Group C officers at the Attorney General's Chambers decided that disciplinary proceedings should be taken against her with a view to her dismissal and informed the Public Services Commission of its decision. Then the Secretary of the Public Services Commission requested the appellant to show reason as to why she should not be dismissed, and the appellant reply gave her reason for wearing the purdah, and she quoted verses from the Quran. However, the Public Service Commission decided to dismiss the appellant from service under General Order 26 of the Public Services, the Public Officer Conduct and Discipline, Chapter D, General Orders 1980.
Moving on to issues. First, whether in dismissing the appellant, the respondents had acted fairly and had strictly complied with the provisions of the General Order D. Second, whether wearing of a purdah is an Islamic injunction which ought to be strictly followed by Muslim women.
The issue of the case. Issue number 3. Whether paragraph 2.2.1 of the Service Circular No. 2 of 1985 in prohibiting the wearing of such attire had infringed the appellant's constitutional right to practice her Muslim religion. Issue number 4. Whether paragraph 2.2.1 of the State Service Circular was vague and uncertain.
Alright, so now we'll take a look at the ground of judgment for issue number 1, whether in dismissing the appellant, the respondents had acted fairly and had strictly complied with the provisions of the General Order D. So what did the judge say on this matter? So the court held that, firstly, the procedure adopted by the chairman of the disciplinary board and the PSC followed strictly Orders 24 and 26 of the State General Order D. Secondly, PSC had acted fairly and properly against the appellant by giving her every opportunity to be heard. Thirdly, it is also clear that it was only after due consideration that the PSC decided to dismiss the appellant from service. The appellant maintained her ground, saying that the first respondent had breached the rules of natural justice in failing to inform her of the complaints against her. So the court held that, firstly, the first respondent's decision under Order 24 of General Order D is not required to be conveyed to the plaintiff or to anyone else. Secondly, the purpose of Order 24 of the General Order D is quite clear. When the chairman of the appropriate disciplinary board receives the report, he is not required to convene the board meeting. Thirdly, It is enough that he considers the gravity of the alleged disciplinary offence committed and decides whether, under the circumstances, proceedings should be taken with a view to dismissal or not. Alright, and now, the ground of judgment for issue number 2, which is whether the wearing of a purdah is an Islamic injunction which ought to be strictly followed by Muslim women. So what did the judge say on this matter? The court accepts the opinion of Datuk Mufti Wilayah Persekutuan that Islam as a religion does not prohibit a Muslim woman from wearing, nor requires her to wear a purdah.
Next, ground of judgment for issue number 3. What is issue number 3? Issue number 3 is whether paragraph 2.2.1 of the Service Circular number 2 of 1985 in prohibiting the wearing of such attire had infringed the appellant's constitutional right to practice her Muslim religion. The court held that, first, the identity of a person wearing a purdah is difficult to determine. Therefore, if is it allowed to be worn during office hours, a person who is not an officer at a particular government office may pretend to be a lady officer working there, and the secret files kept there, which can lead to disastrous results. Second, government secrets and interests must be safeguarded at all costs. It is true that Article 11, Clause 1 of the Federal Constitution guarantees the freedom of religion, where every person has the right to profess and practice his religion. However, such right is not absolute, as Article 11, Clause 5 provides that this article does not authorize any act contrary to any general law relating to public order, public health, or morality. In the context of Service Circular 2 of 1985, the court is of the opinion of such prohibitions does not affect her constitutional right to practice her religion, even though the conditions imposed may restrict to some extent the religious practice of some of its officers. Ground of judgment for issue number 4. What is issue number 4? Issue number 4 is whether paragraph 2.2.1 of the said Service Circular was vague and uncertain. The court held that, first, the condition the said Service Circular was vague, unreasonable, and unlawful, and that appellant was not obligated to comply with it because the operated dress did not refer to the word purdah, cannot be sustained. Second, that paragraph clearly is intended to apply to all lady officers in the public service who are required to wear during office hours suitable and presentable attire, except jeans, slacks, shorts, and any attire covering face. In the context of paragraph 2.2.1, purdah, as worn by the appellant, will come within the meaning of any attire covering face. It could not therefore be said that the circular or the paragraph in question was unclear to the appellant or that she could not understand its meaning or purpose. The court therefore dismissed the plaintiff's application with cause.
Firstly, we will look into the facts of the case Meor Atiqurrahman bin Ishak and others v. Fatimah binti Sihi and others. First, the wearing of a turban by an adult Muslim male, even if commendable, certainly does not rank on the same level as Sunat prayers. Second, this was not a total prohibition of the wearing of the turban. Considering the circumstances under which the prohibition was made, it must be accepted that Malaysia is a multiracial, multicultural, multilingual, and multi-religious country, and by any standard, Malaysia's success has been miraculous in terms of unity, peace, and prosperity. Third, the School Regulations 1997, insofar as it prohibits the students from wearing the turban as part of the school uniform during school hours, does not contravene the provision of Article 11, Clause 1 of the Constitution, and was therefore not unconstitutional. The three appellants were primary school students at Sekolah Kebangsaan Serting Hilir Felda, Bandar Baru Serting Negeri Sembilan. The school had issued the Peraturan Sekolah Kebangsaan Serting Felda 1997, which is the School Regulations 1997, made pursuant to Surat Perkeliling Ikhtisas Bill 9, 1975, issued by the Ministry of Education. Regulation 3 of the School Regulations 1997 stipulated the uniform for male pupils. Regulation 3.1 specifically prohibited all pupils from wearing jubah, turban, which is serban, topi, ketayap, and purdah. The appellants wore turban as part of the school uniform to school, and they were advised repeatedly not to do so, and to comply with the School Regulations 1997, but they refused.
Timeline case. On 4 August 1997, the first respondent wrote a letter to Sheikh Ahmad Johari Sheikh Muhammad to make sure the appellants wear songkok instead of serban to prevent any disciplinary action from being taken upon them. The guardian ignored the letter. On to September 1997, the headmistress ordered the first appellant to take off his serban and substitute it to songkok if he wanted to study at the school. On 3 September 1997, during a morning ceremony, the first appellant was entitled to receive reward from the headmistress. He had on his head a serban. The headmistress then hit his head with a pencil and asked him to go back home. On 4 September 1997, the headmistress again asked him to go back home after she hit his cheek with a file and flicked his forehead when she bumped into the first appellant. On 5 September 1997, the headmistress brought the issue to the Persatuan Ibu Bapa dan Guru PIBG through a letter which the headmistress addressed to the guardian. She asked him to exchange the appellants to another school. The guardian again refused to follow the order. On 27 September 1997, during examination, the headmistress punched the first appellant on his right cheek.
On 3 November 1997, the appellants were expelled from the school with effect from 10 November 1997. Thus, the appellants challenged their dismissal in court.
Moving on to the issue of this case. Firstly, whether regulations prohibiting wearing of the turban by school pupils during school hours violated Article 11, Clause 1 of the Federal Constitution. Secondly, whether Regulation 3, Part 2 of the School Regulations 1997 was unconstitutional. And thirdly, whether right to wear a turban is an integral part of the religion of Islam.
And now, let's move on to the ground of judgment for this case. The High Court held that the School Regulations 1997, which prohibits against wearing of turban by male students in schools, is unconstitutional. This is because there is no prohibition regarding the wearing of turban in the Federal Constitution. The Peraturan Pakaian Seragam Bill 3 1983 does not prohibit students from wearing turbans and purdah, and this made the prohibition of the defendant, as in the School Regulations 1997, as invalid and void. The defendant does not have the jurisdiction to make prohibitions as in the rules of School Regulations 1997. Therefore, the court ordered the plaintiff to return to school and the defendant to pay the damages.
However, the defendant appealed to the Court of Appeal, and the Court of Appeal reversed the judgment of the High Court. The Judge Abu Hamid Muhammad raised issue whether regulation prohibiting wearing of turban by school people during school hour violated Article 11, Clause 1 of the Federal Constitution or not. The Court of Appeal viewed that wearing turban is considered as sunnah, and it is not mandatory, wajib. It was not a total prohibition of the wearing of the turban. The prohibition of the wearing of turban as part of school uniform was only during school hour, meaning that the plaintiff is free to wear turban at any time and anywhere except during school hour. Therefore, the Court of Appeal decided that the prohibition of wearing of the turban as part of the school uniform during school hour in the School Regulation 1997 did not contravene the provision of the Article 11, Clause 1 of the Federal Constitution, and therefore it was not unconstitutional.